Thank you so much, ladies and gentlemen, for braving the rain in your hunger for constitutional education and illumination. You've picked a great afternoon because we have a blockbuster group of two of the most thoughtful federal judges in the US debating one of the most important questions of criminal justice in our time, namely, is the sentencing system broken, and why do innocent people plead guilty? This is an exciting time, as always, for the National Constitution Center, which is, as one or two of you have heard, the only institution in America chartered by Congress to disseminate information about the US Constitution on a nonpartisan basis. And it is exciting in these polarized times that we are able to bring together the most thoughtful voices from all sides of the spectrum to debate not political issues, but constitutional issues, so that people can make up their own mind. We've got a phenomenal series coming up in the fall of our role as America's Town Hall. The new season opens on September 17th, Constitution Day, where Justice Stephen Breyer will be with us to launch the best interactive constitution on the web. And we have brought together, with the co-sponsorship of our great partners at the Federalist Society and the American Constitution Society, the top scholars in America to write about every clause of the Constitution, what they agree about and what they disagree about, and this will be available free online, and it's launching in September. And our program will soon be online and mailed to all of you. It includes Senator Chris Coons on the Constitution, Chief Charles Ramsey launching an exciting new program about police legitimacy, where the police from around the country will talk to school kids here at the Constitution Center about the Constitution. And on September 21st, to prepare for the Pope's visit, we will have an exciting opening of a new exhibit on religious liberty with treasures of the most significant documents of religious liberty in American history, including George Washington's first Thanksgiving proclamation and his letter to the Roman Catholics and Jews of America, and top scholars debating religious liberty past and present. So it's going to be a phenomenal fall at the National Constitution Center. It's now my great honor to introduce our two panelists. Jed Rakoff is a judge on the US District Court for the Southern District of New York, one of the leading legal intellectuals in this country, as well as one of the great contributors to debates about the kind of questions involving criminal justice that we'll talk about today. He has good Philly roots. He was born here in Philadelphia and went to Swarthmore and Oxford before going to Harvard Law. And he ignited a constructive national debate about plea bargaining with his path-breaking article in the November 20th, 2014 issue of the New York Review of Books, Why Innocent People Plead Guilty. And his article provoked an energetic response from his co-panelist today, Judge Michael M. Baylson. Judge Baylson is a judge on the US District Court for the Eastern District of Pennsylvania. He too has Philadelphia roots, and in fact, it turns out that there's a family connection that the judges may tell us about. He went to the University of Pennsylvania for undergrad and for law school, and has served with great distinction here on the Third Circuit since he was appointed in 1988. Gentlemen, let's get right to it. First of all, ladies and gentlemen, please welcome Judge Baylson and Judge Rakoff to the National Constitution Center. Judge Rakoff, let's start at the end of your article, where you actually talk about reforms for what you consider an unfair plea bargaining system. You say, if there were the political will to do so, we could eliminate mandatory minimums, eliminate sentencing guidelines, and dramatically reduce the severity of our sentencing regimes in general. President Obama was here in Philadelphia yesterday at the NAACP, and I gather he made some proposals that suggest that he read and agreed with your article. What exactly did the president propose, and what do you think of his proposals?
So thank you, Jeff. And first of all, let me say how privileged I feel to have been invited to this. I didn't know till you just mentioned it that your organization was chartered by Congress, which is surprising to me because I didn't know Congress could agree on anything. So some of you may have read in today's papers that right here in Philadelphia yesterday, President Obama called for the reduction or perhaps total elimination of mandatory minimum sentences and also a general reduction in sentence severities across the board. And I think that was a reflection of two things. First, a recognition, I think, by many people that the mass incarceration we have in this country, where 2.2 million people are in jail, and where the great majority of them are young men of color, is frankly not only an abomination, but something that has done terrible destruction to the entire African American and Hispanic communities. It is a rate of incarceration, both in absolute and in per capita terms, that is far greater than any other country in the world. Crime rates have been declining in the United States for the last 24 years, and yet our incarceration rate has remained the same or even gotten higher because we are locking up ever more people for ever longer periods of time. And it was really thrilling to me to hear the president's proposal. But what I also think it represents is there is a surprising, but to my mind, wonderful growing consensus from both the right and the left that this problem has got to be dealt with, and that the laws that we put into place in the 70s and 80s when crime rates were rising were perhaps misguided, or certainly have been used in ways that none of us would want them to be used, and that we need to do something about it.
Judge Bilson, there is indeed, as Judge Rakoff suggests, this growing consensus which unites President Obama from the Democratic side to people like Rand Paul, who was here at the National Constitution Center recently and called for sentencing reform. Do you agree or disagree with the president's proposals?
Well, I agree with a lot of it, but I think this is a far more complex program than just saying problem than just saying that there are too many people in jail. And let me just make a couple of short points, and we can develop them as time allows. First, about mandatory minimums. The Judicial Conference of the United States, which speaks for all judges, all federal judges that is, on policy matters, has consistently opposed mandatory minimums. And nonetheless, they have been enacted by Congress across a wide swath of crimes: drug crimes, firearm crimes, arson crimes. And the one factor that many people leave out is that the way a defendant who is charged with an offense that carries a mandatory minimum can avoid the mandatory minimum is by cooperating with authorities. And cooperation is a very important part of law enforcement and of making sure that all individuals who are responsible for a crime get prosecuted, and if they are found guilty, get imprisoned. And that has been very effective. Now, that is not necessarily enough of a reason to have mandatory minimums, but if we do away with them, there may be some cost in public policy of having less cooperation. Secondly, the term mass incarceration has become a slogan for this reform movement. And we just have to pause for a minute and remember that every individual who is in jail today is there because a judge, either a state judge in most cases or a federal judge, has imposed a sentence as they're authorized by law to do, because that individual was convicted of a crime. Now, I was U.S. Attorney during a period of rising crime rates, and one of the responses that Congress enacted with support of President Clinton and very strong bipartisan support by Republicans and Democrats in Congress was to adopt mandatory guidelines and to adopt a number of mandatory minimums. And the crime rates have gone down. Now, there's a great body of literature by criminologists that debate whether crime rates have gone down because more people who were inclined to commit crimes have been in jail. I don't know the answer to that, but it is a question that deserves discussion in the public realm.
So the question is well and truly joined, Judge Rakoff. You say in your article that the rise of draconian mandatory minimums has created the virtual extinction of jury trials in federal criminal cases. In 1980, 19% of all federal defendants went to trial. By 2010, it's less than 3%. And you said that one reason for this is that mandatory minimums allow prosecutors with weapons to bludgeon defendants into effectively coerced plea bargains. Judge Baylson worries that fewer defendants would cooperate. You suggest that this would be a good thing because this is not voluntary cooperation. Tell us more about that.
Well, I mean, let's start with the statistics. First, before mandatory minimums and the sentencing guidelines, for many, many decades, between 15 and 20% of all persons who were charged with a crime and whose cases were not dismissed at the outset for technical reasons or whatever, went to trial. Almost immediately after the mandatory minimums and sentencing guidelines came into place, that percentage dropped from 15% to 3%, and that's where it's remained to this day. Only 3% of all defendants feel that they can even test the system by going to trial. And I think that in itself leads to abuses. So why has that happened? Well, typically a prosecutor will say to a defendant, I am going to charge you, or I already have charged you with the maximum that I think I can prove, and these include mandatory minimums that mean you're going to prison if I convict you for 10, 20, or more years. The judge will have nothing to say about it if you're not a cooperator. But I'm willing to fashion a plea bargain that will reduce it to 5 years, let's say. And in fact, the overall statistics are that those who go to trial receive approximately 3 times the sentence of those who do not go to trial. And so the defendant, including in my view a percentage of totally innocent defendants, will take the, if you will, the risk-adverse position and enter a guilty plea without any testing ever having been done of the government's proof. Now, Judge Baylson, who in many respects I've learned a lot from, and I want to make clear that we agree on as many things as we disagree on, but Judge Baylson talks about cooperators. When I was a federal prosecutor for 7 years in the 70s, doing mostly white-collar prosecutions where there were no mandatory minimums, we had no trouble getting cooperators. I don't think there's any real evidence that mandatory minimums have led to more cooperators. But even assuming arguendo, as lawyers would say, that is the case, that you're talking about a relatively small percentage of all defendants. A sensible prosecutor will only cut a cooperation deal with 1 or 2 people in a given case. Typically, they're the first ones who come in, and they're people who are not at the very top of the chain, but not at the very bottom. They need to have enough knowledge to be able to cooperate against the top people. So you cut the deal with them, and they escape the more harsh severities of mandatory minimum. But that would be in a typical, let's say, a narcotics case involving a dozen or more defendants. That might be 1 or 2 of the people. All the others would be pleading guilty pursuant to plea bargains to mandatory minimums that were imposed regardless of what the judge might think, because Congress doesn't have faith in judges in their ability to determine what the right sentence is. But it would be a far less mandatory minimum than the prosecutor could charge, and that's what leads to these pleas.
Judge Bilson, you have a bunch of things to say in defense of mandatory minimums, including the fact that they were adopted by Congress and that whether judges like them is irrelevant. Congress makes the law. Many believe these laws deter crimes. You say that sentencing guidelines used to be mandatory, but now they're only advisory. They weren't adopted to bludgeon defendants, but with the careful work of Senator Kennedy and Justice Breyer. And above all, you say that it's wrong, as Judge Rakoff suggests, that prosecutors have the upper hand, defendants have a strong weapon. It's called the presumption of innocence and the requirement to prove cases beyond reasonable doubt. Tell us more about why Judge Rakoff is wrong.
Well, he's not entirely wrong, but he emphasizes some situations that do exist in some cases. You can't talk about plea bargaining as if they are one size and one shape. There are many different types of plea bargaining as there are fish in the sea. There are some defendants, actually there are many defendants, who are interested in pleading guilty because they believe that they know that they did commit a crime. Now, maybe they have been overcharged, or maybe they're not as guilty as the prosecutor says, but they know that there's some risk that if they go to trial, they may be convicted of more serious crimes than they can be punished for if they plead guilty. So there is a high motivation by many defendants, this is true in both state and federal court, to plead guilty to something. And that leads to a plea bargaining dialogue between the prosecutor and the defense lawyers. Now, the Supreme Court has never said there's anything wrong with plea bargaining. There's a recent decision where the court said that a defendant has the right to know that a plea bargain has been discussed between the defense lawyer and the prosecutor, but there's nothing inherently wrong about plea bargaining. As a matter of fact, that is the regime of more than 90% of the disposition of criminal cases in the United States, as Judge Rakoff has indicated. Now, one word about the sentencing guidelines. 25 or more years ago, the great outcry of criminologists and legislators were that there was too much disparity in sentencing, particularly for defendants who committed similar crimes across the country and received very disparate sentences. And that's what led Justice Breyer, who was then an appellate judge, and before that was a Harvard law professor, and Senator Kennedy. And by the way, Justice Breyer had been a staff member for Senator Kennedy years before that, so they worked together for a long time. And they were the prime motivators of the sentencing guidelines, and the primary purpose was to reduce or eliminate disparities in sentencing. And that was the mantra that carried the day why Congress established the guidelines and empowered a bipartisan sentencing commission to study them and to adopt them. And the Sentencing Commission's initial guidelines, which were mandatory, were based on actual sentences that had been imposed across the United States. And now that, in 2005, the Supreme Court said that the mandatory nature of guidelines was unconstitutional and gave federal judges discretion in sentencing unless there was a mandatory minimum. And cooperation has continued to a large extent. But cooperation is more significant in cases where mandatory minimums apply. Now, as I said before, that's maybe not enough of a justification. I recently had a case here, the ironworkers case, where there were 12 defendants, and 6 of them cooperated against the leader of the union and testified. And the reason those 6 did so, and the prosecutor said this in open court, was because they had been charged with arson offenses, which carry a mandatory minimum. And by the way, they were all white males. So that's what I said. There are many fish in the sea, and there are many different types of criminal prosecutions. And it's hard to generalize.
Judge Rakoff, we jumped right in at the end by talking about mandatory minimums and the president, but you begin this remarkable article by making a claim about history. You say that the criminal justice system in the United States today bears little relationship to what the founding fathers contemplated. You quote Thomas Jefferson, "I consider trial by jury as the only anchor ever yet imagined by man, by which a government can be held to the principles of the Constitution." And you say, despite the Sixth Amendment guarantee of a speedy and public trial by an impartial jury, 3% of federal cases go to jury today. And you also say that the result of this temptation to plead guilty is the conviction of the innocent. The gravest objection of all is that a significant number of defendants plead guilty to crimes they never actually committed. Tell us first, what happened historically? Why was it that Until the Civil War, plea bargains were exceedingly rare, and now they're so common. And then tell us a little bit more about the dangers of convictions of the innocent.
Well, the plea bargains were viewed in the 19th century by the courts, including the Supreme Court, as in derogation of the search for truth. The thought was that if someone is charged with a crime, they ought to have their day in court. The government ought to be put to its proof, and either it would establish that a crime had been committed or not. The reason plea bargains came into being initially was the very practical one that beginning after the Civil War, there was an increase in crime, largely because of economic dislocations, and the courts were swamped with more cases than they could handle, and so the notion of plea bargains came about. In much of the world, plea bargains are still frowned upon, but my own view is that within limits, they are a practical solution to the fact that we just can't bring every case to trial. But it got way out of hand, is my suggestion, beginning with the laws in the 1970s and 80s, so that instead of 15 to 20% of cases going to trial, only 3% do. Now, the sentencing guidelines are an interesting side issue, but I'll just respond quickly to some of the points made by Judge Baylson. It is true there was a problem of disparities in sentencing, and that's what motivated the guidelines. Justice Breyer, who I believe is well on his way to changing his mind about many of these issues, if you read his dissent 2 weeks ago in the death penalty case, where he essentially says it's time for the Supreme Court to see whether the death penalty is unconstitutional, and gives, I think, about 40 or 50 pages of innocent people being convicted in death penalty cases. But Justice Breyer and others believe that a number system, in effect, an arithmetic system, would do away with the disparity. I think it was a good idea in theory. It has proven to be a bad idea in practice for several reasons. First, Congress has repeatedly told the Sentencing Commission to up the ante. Judge Baylson points out that originally the Sentencing Commission took the mean of all sentences throughout the United States. The present guidelines bear no relation to that. Professor Kate Stith at Yale has done a study, for example, in the white-collar area, the sentences are now, under the guidelines, 500% higher than they were when the guidelines were initially put in place. And of course, mandatory minimums trump the guidelines in any event, and they're particularly potent in narcotics cases, which is a big part of the federal criminal docket. Secondly, the biggest motivating force, so far as at least liberals were concerned, like Senator Kennedy, in favor of the guidelines, was the thought that there were racial disparities in sentencing. But the guidelines, ironically, imposed a much greater racial disparity that we only did away with a very few years ago. The guidelines said that every ounce of crack cocaine would be treated for guideline purposes as the equivalent of 100 ounces of powder cocaine. Overwhelmingly, those who are convicted in crack cocaine cases are African American. The great majority of those who are convicted in powder cocaine cases are either white or Hispanic. The result was an unbelievable disparity, racial disparity, between sentences in crack cocaine and powder cocaine cases that was far, far greater than any perceived racial disparity that had existed before the guidelines. And Finally, I think the guidelines obscure the fact that there are still huge disparities, but they are no longer disparities between judges, they are disparities between prosecutors. Because with 97% of all cases being negotiated as plea bargains, it's really those plea bargains that set the sentencing range for all practical purposes. Some prosecutors are more sympathetic to defendants than others. There's a great disparity among prosecutors, and even more so among U.S. attorneys' offices in different districts, as to what's the appropriate plea bargain in a particular case. That is not exposed to any judicial scrutiny whatsoever. It's all done behind closed doors and then presented as a package to the judge. I think all the things that the guidelines were supposed to cure have not been cured, and we have created instead a worse situation with the guidelines. Having said that, they pale in comparison with the evils of the mandatory minimums, which essentially take sentencing out of the hands of judges altogether. That's the real effect of them.
Lots of powerful points to respond to, including the idea that these guidelines intended to reduce disparities, including racial disparities, have exacerbated them, and they have put tremendous discretion in the hands of prosecutors, some of whom have a policy of encouraging cooperation and downward departures, as you say that you did as a U.S. attorney, where you resulted in a third of all sentences imposed in the district having downward departures, but others don't.
Judge Rakoff is absolutely correct about the about the background of the guidelines and about the congressional insistence that judges impose tougher sentences for crack than for ordinary cocaine. This existed for a number of years. It was recently lessened by another act of Congress called the Fair Sentencing Act, and we are now allowed to reduce retroactively sentences that were imposed for many crack defendants, not all of them, but for most of them. But the fundamental problem that exists, in my view, is that there are still mandatory minimums that result in a lot of sentences. Now, one of the important points that Judge Rakoff meant, but is stated in his original article, was that innocent people were being convicted, were motivated to plead guilty. Now, I think one of the fundamental jobs of a judge, whether in state court and federal court, that over 90% of the crimes, of the prosecutions of crimes in this country are done in state courts. Federal courts are like the tip of the iceberg. But we set an example in a lot of ways, and we have a lot of the bigger cases so that there's a lot of impact from what federal judges do. One of the great advances in the last 10, 15 years or so have been the discovery, largely through DNA and other weeds, that many people, and more than one is too many, innocent people have been convicted of crimes. And I'm close to a lot of the people in Pennsylvania who are involved in finding and remedying the conviction of the innocent. And some of them are in the audience, including the executive director, and they have done a tremendous job of uncovering wrongful convictions. And when I say innocent, I mean actually innocent. That is, the person did not commit any crime whatsoever, but was nonetheless convicted. Sometimes innocence is used, well, I was convicted of first degree, but I was only guilty of second degree. That's not, to me, actual innocence. But one of the problems, in my view, is that judges are not being tough enough in assuring, when they take a guilty plea, that there is a factual basis for the plea. Rule 11 of the federal rules require that the judge do that. And I try and live up to it, and I'm sure Judge Rakoff, and I'm sure most federal judges try. But occasionally is still too many. Guilty people are motivated, not guilty, innocent people are motivated to plead guilty for the wrong reason because they're afraid of getting convicted even though they did not commit any crime whatsoever. And that is a defect in our system that requires remedy.
Okay, Judge Rakoff, let's talk about the exoneration of the innocent.
Because here we are in total agreement. But just to put some more flesh on that bone, the National Registry of Exonerations, this is a group at the University of Michigan that keeps tabs on all actually innocent cases, the type that Judge Baylson was just describing, as opposed to people who said, I've been convicted of something worse than I thought I did, but I did do a crime. But these are people who were totally innocent, were nevertheless either went to trial or were found guilty beyond a reasonable doubt, and their initial direct appeals were denied, or according to the National Registry, of 1,535 persons who have been actually exonerated since 1984, 221 of them, or about 14%, pled guilty. So you may ask yourself, well, how could someone be pleading guilty if they were actually innocent? And what I've tried to suggest is some of the reasons, some of the pressures. There are also situations involving false confessions. There are also situations involving persons who are either mentally retarded or at least mentally, intellectually challenged, and also young people who are easily pressured. But it is a significant number of people, and those are just from the cases where there's been proof of actual innocence after the fact. I totally agree with Judge Baylson that judges should do more about inquiring at the time of guilty plea as to what the underlying evidence is, but consider some of the difficulties. Once a plea bargain is arrived at, the adversary system basically breaks down. The prosecutor is going to get up and say, Judge, our proof would show such and such. The defense counsel, having already cut the deal, is not going to challenge that in any respect. So, yes, judges should do much more in asking their own questions and really trying to get more deep information about what the underlying evidence is. But it's not an easy thing when both sides are saying, Judge, we both agree, this is it, here's what the facts are. And furthermore, we're increasingly learning that a lot of evidence that we once thought was really good evidence is not so good. I have the privilege of serving on the National Commission on Forensic Science, and that commission was set up by the Department of Justice at the behest of Congress because of increasing evidence, much of which I'm sure you've all read about, where forensic science labs faked evidence, where forensic science was portrayed as being much stronger than it really is, things like that. So when the prosecutor gets up and says, Judge, we've got fingerprints or we've got other forensic evidence, is a judge going to at that point say, well, I want to bring in the fingerprint examiner and go through what in federal court is called a Daubert hearing to determine how reliable it is? Very unlikely. Another problem is eyewitness identification. Of the cases where there was exoneration that I referred to previously, at least 1/3 were the result of inaccurate eyewitness identification. These were not witnesses who lied. These were witnesses who, for a variety of reasons, simply made a misidentification. But when the prosecutor gets up in a guilty plea and says, Judge, we have an eyewitness to this crime, and in state crime, that's often the situation, is the judge going to say, well, I want to have that witness come in and I want to test out just how strong that eyewitness identification was? As a practical matter, that's not going to happen. So I think, as Judge Baylson has correctly said in other respects, it's a very complicated problem.
Judge Bilson, Judge Rakoff has a specific proposal for involving judges in the plea bargaining process. He advocates what a few jurisdictions, Connecticut and Florida, have begun experimenting with, which is having judges review the case before the plea is entered. He suggests that a magistrate would take witnesses in a closed hearing. No plea could be entered until the magistrate makes a recommendation, either to dismiss the case, to proceed to trial, or to enter into a plea bargain, and no party would be required to follow the magistrate's suggestions. What do you think of that idea?
Well, you finally hit upon something on which we really do disagree.
Good, that's my job.
I think taking the responsibility out of the job of the sentencing judge would be a great mistake. In the first place, we have devoted a lot of resources to the prosecution of and imprisonment of people convicted of crimes. And many people say it's too much. Judge Rakoff's proposal would only add to the expense and burden. And it would relieve the sentencing judge of the responsibility that he or she now has to make the inquiry, to determine whether, if it's a case of identification, whether there is corroborating evidence, how sure the witness is, what the plea bargain is if they're at a sentence. And it would also require a total change in federal law, at least, because under federal law, judges are not allowed to participate in the plea bargaining process. And that is, in my view, is a very important and a very sound reason, because the sentencing judge retains independence over the inquiry, over the sentence to be imposed. Now, many states allow judges to negotiate with the defense counsel and the prosecutor, and sometimes the defendant himself or herself. And I think that is a great mistake, because it tends to sweep the judge into this whole concept of negotiating whether somebody should go to jail, and if so, for how long, and whether they're cooperating, and what they know and what they didn't know. And that's really not a judicial function. So I think the answer to the problem of making sure we do not send people to jail who are truly innocent is to make the judge the responsible party, and not to have another superstructure or bureaucracy or magistrate judges who are already very busy doing a lot of other things. Judge Rakoff's proposal became a reality. We need double the number of magistrates we have, at least in federal court, in my view, and it costs billions of dollars, and we're already spending, everybody says, too much money on this issue already.
Judge Rakoff, why is your expensive and misguided proposal not a great mistake?
So first, I want to make clear that I was driven to this proposal as a secondary proposal. My primary belief, which I'm more optimistic about now than I was a year ago when I wrote that article, is to do away with mandatory minimums, greatly reduce the severity of the sentencing guidelines and things of that sort. This was a fallback proposal if that doesn't occur. But it would not be the same judge who was handling the case. It would be a magistrate judge, and he would not tell the sentencing judge what was going on. What the magistrate judge could do at an early stage of a case, in my view, is make the kind of inquiries I was talking about before. He could find out whether that eyewitness was really any good. He could find out whether that forensic evidence really stood up to scientific principles, and so forth. He could make the kind of detailed inquiries early on in the case without prejudice to either party's position that I think would tend to ferret out cases where the person may well be innocent and being wrongly accused. There are downsides. I think the biggest downside is the one Judge Baylson just referred to, is it might be quite costly. I'm not sure it would cost quite as much as he believes, but it certainly would involve some additional expense. Consider, though, the huge expense that we now undergo when we put people in prison. It costs, if I remember correctly, the last study I saw, it costs something like $60,000 to keep a person in prison for a year, either in state or federal prison. So a magistrate judge makes about $100,000 or so. You could get 2/3 of a magistrate judge, so to speak, if you just eliminated one person from prison. Now, I'm overstating that whole, the arithmetic of all that, but my point is that I think there would be a less obvious but offsetting savings if a lot of people who are now being sent to prison were not sent to prison. I also think, aside from protecting the innocent, that the kinds of questions that a good magistrate judge would put to the prosecutor at the early stage of a case before the prosecutor really got locked in his position would lead to many more cases where the prosecutor agreed to deferred prosecutions, to sending persons off to rehabilitation programs and things of that sort. Judge Baylson, he didn't mention this, but he has been a major mover in some wonderful rehabilitation efforts that have been made here in Pennsylvania. And I think with the help of earlier inquiries by magistrate judges, even greater use could be made of those wonderful programs.
Judge Bilson, do you accept any part of Judge Rakoff's suggestion that the conviction of the innocent reflects the coercive pressures of plea bargaining?
Well, I think there certainly can be some truth for that in some cases. As Judge Rakoff indicated, the great majority of exonerations have taken place in cases where the defendant pled not guilty. And there was some pseudo-scientific evidence that was introduced or faulty eyewitness testimony that is a result of which a jury convicted an innocent person. I think all of us are going to be hard-pressed to say that we can prevent that from happening. What our job is first to recognize that that is a totally unacceptable situation, that an innocent person is convicted, and that we have resources and mechanisms to work for exonerations when they're merited. And these newly developing innocent projects, of which there are many across the United States, have been doing that with remarkable success, and they need to be encouraged. The problem we're talking about here is where people plead guilty even though they are totally innocent. And that is a problem, but in my mind, it's a relatively small problem because most people, the great majority of people who plead guilty, have committed some crime. And you can argue till from dawn to dawn whether they were over-convicted or over-sentenced, or they got off leniently, and there are 10 sides to every story. But the issue is whether someone who is truly innocent feels coerced to plead guilty. And on that, I still say the best way to avoid that is to make the sentencing judge the person responsible for making sure that there is a factual basis for the plea, which is a core requirement of Rule 11 of the federal rules. And every state should be required to have a similar rule and to enforce it and to abide by it.
Judge Rakoff, you disagree that it's just a small number of guilty pleas that result from the pressures of plea bargaining, and you also tell us about the Aaron Swartz case. Aaron Swartz's father wrote a response to your article that was quite supportive of your conclusions, and it had a rather tragic end. Tell us what happened there.
So the criminologists have tried to figure out what percentage of innocent people plead guilty. And I think the fair thing to say is they've had difficulty doing so. It's not easy to ferret that out. When you talk about cases of exoneration, like the Innocent Project and like the National Registry, the percent of people who pled guilty who were actually innocent is always between 10 and 15%, but that's not a fair sample. We want to look at the great mass of people who pled guilty, and the percentages are probably lower. The criminologists' studies, which again I don't particularly place great weight on because I think it's not an easy thing to measure, have put the figure at between 2% and 8%. If being, in my view, quite conservative, we were to believe it was as low as 1%, then we are talking about 20,000 people who are right now in prison who are actually innocent but pled guilty. So that's a pretty substantial number no matter how you look at it. The Aaron Swartz case, which is just one of many that I could recount, was a young student at MIT who was accused of taking data from the database of another university illegally. And the prosecutor saw this as a case in which he wanted to set an example and kept raising the ante of what he would demand if the case either went to trial or even if there was a guilty plea. He was up to 50 years and more when Aaron Swartz committed suicide. I had a client when I was a criminal defense lawyer after I was a prosecutor. I had a client accused of murder who, in my view, was actually innocent. I never got to test that because he committed suicide, and I cannot say I don't have any psychological training, but certainly the fact that the prosecutor in that case was seeking the death penalty was, in my view, a factor in what led to his death. There's a very interesting article which I commend to you all that came out about 2 weeks ago in the Georgetown Law Journal, and it's written by what you might consider an unlikely source, Judge Alex Kosinski. Judge Kosinski is a well-known conservative judge on the Ninth Circuit. For those of you who are not lawyers, the Ninth Circuit is California, Hawaii, Alaska, and all those other beautiful places. And Judge Kosinski is certainly not a judge who's known as a bleeding heart. But in this article, he endorses pretty much everything that I've said in my article. And here, and just to give one example, he talks about false confessions, which are another situation that often lead people to plead guilty though they're actually innocent because the prosecutor's got a confession from them, and so the chance of winning a trial is very reduced. And he says, one of the myths are that confessions are infallible because innocent people never confess. We know now that this is not true. Innocent people do confess with surprising regularity. Harsh interrogation tactics, a variant of the Stockholm Syndrome, the desire to end the ordeal, emotional and financial exhaustion, family considerations, and the youth or feeble-mindedness of the suspect can result in remarkably detailed confessions that are later shown to be utterly false. And I agree with Judge Kosinski.
Remarkable. We have some phenomenal questions from the audience. As always, you've just answered, Judge Rakoff, the question about the statistics on the number of people who are innocent, and you say that even if it's 1%, which you think is a low estimate, that would still be a whole lot of people. One of our great audience members asks, do innocent people plead guilty because they're held in jail for years pre-trial and see no way of returning to their homes but a guilty plea? This motivation has nothing to do with likely verdict or sentence. Judge Bilson.
Well, there can be a number of reasons why people who are completely innocent plead guilty, and it's an abhorrent result. And one problem is that sometimes prosecutors are not ethical, and that is an issue. If you live in a state where you elect prosecutors, that should be an issue as to what kind of ethical regime the head prosecutor, usually the district attorney or the attorney general, demand of their staff, and what kind of investigation they do of a crime to make sure that an innocent person is not pleaded guilty. And the same thing applies to U.S. attorneys' offices. And as Judge Rakoff said earlier, there are 93 separate districts in the United States. Each one has their own U.S. attorney. In theory, they report to the Attorney General in Washington, but realistically, they're very independent, and they follow different practices. And there are over 1,000 district judges like ourselves, and they vary greatly, as you might, some get out on the bed on the left side and some on the right side, and some care very deeply about defendants who are about to be sentenced, and others really don't pay that much attention, and that's just a fact of life. But we have to have procedures and a regimen and an ethical standard that the conviction of one innocent person is wrong. It's just wrong, and it doesn't matter whether it's one person or 1%, it's wrong. And our system won't be perfect until we remove that. That doesn't mean that for all the serious crimes that are committed in this country and for all the danger that lurks by people who are out there wanting to rob and to commit extortions or to rob banks or to embezzle or be corrupt, that we should upend a system that works relatively well for them. We have to prosecute those people because they are criminals, and many of them belong in jail because they are a threat to public safety or they're recidivists. But at the same time, we've got to be on guard that we don't convict anybody who is innocent. And I think we can do both.
So on the, adding to what Judge Baylson said, but on the specific question of detention for years, that's relatively rare in the federal system, but is quite common in many state systems. In New York, you may have read about all the problems they've been having in Rikers Island. The conditions there are terrible, and people have been held there for 3, 4, 5 years before they even get to trial or get to enter a guilty plea. And whether that can be a factor in coercing guilty pleas, I don't know for a fact, but common sense would suggest that it might well be a factor. There are important studies that show that when you're dealing with relatively young people, even being confined for a few days, particularly in solitary, which is a very terrible place to be, can have a dramatic effect on their sense of their self-worth, and they'll do almost anything to get out of that situation. I also agree there's tremendous variation here between U.S. attorneys, between states, and even between judges, although my own belief is that all judges raised in Philadelphia are the creme de la creme. So.
Here. Tell the story. It was your dad taught Judge Bilson's father? What's the connection?
Yes, well, Judge Rakoff's father was one of the leading originators of the medical field called reproductive endocrinology, commonly referred to as infertility practice. And my wife, when she was a medical student and as an intern at Pennsylvania Hospital, worked under him and has great regard for his ability, and I'm very proud of her as a result of his tutelage.
So I would say that Judge Baylson and I sure agree. Really smart people become doctors, and the rest of us.
That was my Jewish mother's complaint as well. Absolutely. We have several questions about the role of the defense counsel, and here is one of them. Judge Rakoff speaks in his article about how defense counsel is at a disadvantage from the outset with less information at their disposal and limited time with their clients. Are there changes in the system that can be made to alleviate this disadvantage and perhaps reduce the necessity of plea bargains for these reasons? Both.
Well, we haven't mentioned today what we refer to as the Brady Rule. The Brady Rule refers to a U.S. Supreme Court case that obligates prosecutors to disclose exculpatory evidence. If that rule is followed, as it should be in every case, that would dramatically, in my view, reduce the incidence of the truly innocent people being convicted or being allowed to plead guilty. But it's not followed universally as it should be. you like to?
No, I totally agree with that. And many judges, in many opinions, have spoken out about that, and you will see in cases of exoneration frequently reference to people who either confessed to the crime themselves, but the police discounted the confession, or the eyewitnesses who said it was someone else, and that wasn't brought to light. It is compounded, though, by the fact that prosecutors, for I think wholly legitimate reasons, namely saving resources, will give the best plea deal to the person who agrees to plead guilty earliest. So if you're a defense counsel, when you get into a case, and you go to talk to the prosecutor will typically say, look, if you're willing to plead guilty, and I think your guy is totally guilty, if you're willing to plead guilty in the next 2-3 weeks, I'll give you deal X. And the implied message, which is usually carried out, is if you wait, you will not get the same deal. And it applies also to the cooperators that were mentioned before. It's the potential cooperator who comes in first who gets the better deal. Now, one unfortunate side effect of that is that much of the Brady material that would have been discovered if the defense attorney had put the prosecutor to the test, I'm not talking in trial, I'm just talking about in the offices, saying, you know, I've been doing my own investigation and I hear there's this other person out there who might well be the culprit. What about that? That doesn't happen because the deal is set early on, and so the prosecutor himself may not even be aware of some of that Brady material. So there is a problem here. I don't have a quick solution to this particular part of the problem, but the perfectly legitimate desire of the prosecutor to wrap things up early because of the huge demands on their resources can sometimes lead to Brady material not emerging at all.
This is what was going on with Greece in the last month. They were negotiating a plea deal, and that what the terms were going to be for Greece to be sentenced, and we all see what the result is.
Gee, that seems such an apt analogy.
Defendants do not have the option of a Grexit, however.
You're right.
I think it's time, gentlemen, for closing arguments. Judge Baylson, you've provoked an extremely salutary national debate with this important article. It's striking that Judge Kaczynski has, from the other side of the aisle, has endorsed your conclusions. Tell us, why did you decide to write this? Why did you go out on a limb? Why do you think it's important? And why is it important that the reforms you advocate be accepted?
No, it's addressed to you, Eddie.
Yes, and then he can respond and tell you why you're wrong.
I'm sorry, you want me to go
Yes,
first?
but you-
I'm sorry.
Yeah.
Well, I was led to write this article for basically 3 reasons. First, the Federal Judicial Code of Conduct affirmatively encourages judges to speak out on issues involving the administration of criminal justice. In other areas, judges are not told to do that, but the code affirmatively imposes that. It's not an absolute obligation, but it's a strong encouragement. In the 20 years that I've been on the bench, I became ever more aware of how little I knew about the persons I was sentencing, about the cases in which they had pled guilty. I may have failed to meet Judge Baylson's proper suggestion that judges inquire at length before accepting a guilty plea. But these cases would come back to me. They would come back to me in habeas petitions. They would come back to me when someone was got out of prison and would be arrested on a violation of probation or the like. They would come back to me in letters that I received sometimes years later from the defendant himself. And I began to mistrust how the system that I was a part of was operating. And it was really more that personal bewilderment that led me to write the article more than anything else.
Judge Bilson, having heard this colloquy, what are your final thoughts?
Well, my final thoughts are that Judge Rakoff has illuminated what is a problem in some cases. The problem I had with his article was I thought it painted too broad a brush. It ignored the differences between federal rules and what goes on in a lot of states. And it didn't pay enough attention of the responsibility that every judge has to make sure that an innocent person does not get sent to jail. But that it did, and it just really made it sound like plea bargaining as a concept was wrong, and that we should do something else. And I think that what we need to do is to insist on high ethical behavior, insist on adherence to the Brady Rule, and insist on judges taking responsibility that the rules are adhered to. And that I'm not sure we're ever going to solve this problem 100%, but if we're on the lookout for it, I think that our justice system is still the best one in the world.
Judge Rakoff, in fact, the New York Review gives the last word to the author, so you get one final rejoinder.
I think judges have a built-in bias towards believing that their system is basically working well. Many years ago, Learned Hand, who was obviously one of the greatest judges in the history of the United States, in one of his opinions said that the notion that our procedure has always been haunted by the ghost of the innocent person convicted. It is a total fallacy. We know now that that is not true. But why did such a distinguished judge as Learned Hand believe it? I think in part it's because when you're part of the system, when you're trying your best to make sure that justice is done, and I think that is true of the overwhelming majority of state and federal judges in this country, it's very hard to accept that maybe what's coming out of that system may not be nearly as good as you think it is. And so it's hard, I think, for judges to be objective. For better or worse, I've come around to the view that the system is much more fallible than I think Judge Baylson believes.
Ladies and gentlemen, please join me in thanking Judge Baylson and Judge Rakoff.